obedience of the court order. There has been no compliance, absolutely. In other words, they are not taking the orders of this court seriously. And that does present a very big problem. Secondly, even if we were to believe them, and we don't, that they do not have him, their business is to investigate and know about the welfare of Kenyans. That's why we pay them, that's why they exist. Ndiangui went missing on the 21st of last month. Today is the 1st. So we are talking of 10 days ago. His family did not just complain to the media. They went to Kenol police station and reported on the 23rd. And that is in the affidavit of Lawrence Muturi. The first affidavit, the supporting affidavit. So from the 23rd to today, there's nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations and what they have done, if at all, to find Ndiangui Kinyagia. This matter has been very, very public, to the extent that yesterday, my Lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders, therefore we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiangui Kinyagia in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the inventory of the things taken from Ndiangui Kinyagia size. Is page 10 and 11. If you look at that, my Lord, and look at our annexure attached to the affidavit, further affidavit of Lawrence Muturi, sworn on the 27th day, yesterday, not yesterday, 27th day of June, which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiangui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my Lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, floor FM1. Ours is in color. Theirs is in black and oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my Lord.
Just give me a minute.
Okay.
Yes, continue.
My Lord, if we start with the date, oh, sorry, may I seek your indulgence to draw your attention that Kipe Mungai has joined our team, and also that Monday opening, I'll be assisted by Abna Mango and Willis in responding. My Lord, if you look at the date, on the one by the respondents, it is indicated 21st with ST on top of 21st.
So that is the one from your side?
From the respondents. I'm beginning to show the differences. Why we conclude, we say it is a possible forgery. If you look, if you compare with the one by the in support of the petitioner's affidavit, the date 21st has no ST. It's just 21st June 2025. A further difference, 2025 on the petitioner's supporting affidavit is typed, while the 25...
I thought you go over the respondents.
Okay, let me do that.
And when you are done, you now come to the petition.
I'll do that.
So that there is...
It's methodical.
Yes.
Okay.
So
the differences, we have noticed several differences.
21st.
I had ST to signify 21st.
Yes.
And the date 2025, 20 is typed, yes. 25 is written by hand.
Yes.
Then it has 6 items. It ends at number 6.
Yes.
Then it has the name of a witness, Jane Jango. Then when you come to the respondents, not to the respondents, to the applicant, to the petitioners. I'm done with the respondents.
So the differences are?
The differences are
date
21st does not have an ST, and the year.
6. I'm done.
And
I've marked 21st ST.
Yes, and then the 2025 is typed wholly. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started with ours.
So I'm confirming that I got you right.
Yeah, the differences are
21st
ST and 25 written in pen instead of typing.
Then the items
are 6.
The witness, Jane
Jango.
Mm-hmm.
Yes.
Okay.
Those are the 3 notable things in that one. Mm-hmm. On the one by the petitioner,
yes.
The date does not have ST. And I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other.
No, let's go.
All of it, yeah.
No, let's go the way you went.
Okay, and then I come back.
Then you now
come back.
Highlight the one you think
okay.
is outstanding.
Inventory of items above the date taken. Mm-hmm. Inventory of items taken. Mm-hmm. It says seized from inventory of items taken, stroke seized for the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My Lord, this one has 7 items. That is the petitioners. And there is overwriting on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled.
Number 7 is cancelled.
Number 6 is cancelled. Number 7,
Item.
the numbering. The numbering. You can see a cancellation on the letter 6, and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioners have 7 items and the numbering has been changed.
Yes.
Then we go.
What about witness?
Witness, it is cut, but it appears, the signature appears to be there. This one, yeah. Signature. But there is still the layout appears different at the end from this other one. Where is it? And it has the following words after number 7. It has recovered from name House of Kinyagia Ndiangui. You can see House of Kinyagia Ndiangui. .096 is not there. Sergeant 096. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7, the difference is actually not the writings, is that on our annexure, the petitioner's annexure, item number 7 is on page 1. There is no page 2 of the inventory. It's whilst...
So the petitioner's documents have only one page?
Only one page.
No? One page.
Whereas the respondents is 2 pages. You'll see that number 7 is on page 2. Ours, it's all on 1 page. You will also notice. Oh, this is the time. Yeah. But you see the one with the court is black and white. Yeah, we can leave it for now. So what we are saying. do not have the signature of Oyala.
Yes.
This one is not anywhere here.
Yes. Yes. It's not there.
And this is seized. This is seen. Where did I see seen? No. No, the word seen. This is seen. It also has the word seen. This one. No.
Yes.
This.
Yes.
The last distinction between the two I would like to point out now is on the respondents. On the respondents, if you look at below the Directorate of Criminal Investigations, it is inventory of items taken, seized from the suspect, seen for the purpose of investigation. Now, if you look at the petitioners,
The word inventory appeared at the top.
the word that is not similar in both is the word sin, as in sin of crime. Whereas the respondents, one, in that heading, has the word sin, and these are typed. The word sin does not appear on the copy of the supporting affidavit of the petitioners. Yeah. I'm not a document examiner, but even the writings appear different. So with respect, we suspect that the exhibits annexed to the replying affidavit of the respondent, Koplo Itegi, are a forgery. And following the press conference of the second respondent, with respect, we see him as a person of interest, and we would be happy to cross-examine him if he was in court. I do not think, my Lord, that you'll be able to get to the bottom of this matter without his personal appearance and without the appearance of the Inspector General. Apart from the need to comply with court orders, law enforcers cannot become lawbreakers and fail to comply with court orders. As I yield to my colleagues, my Lord, you will note from the documents, and I've already stated it, that Ndiangui Kinyagia has been missing for the last 10 days.
Yes.
I just want to say, my Lord, with respect that it appears, because this is not the first case, that detention without trial is being returned. Kenyans refer to the KANU era when it happened as the dark days. Those dark days, my Lord, at least the state used to acknowledge it's holding somebody by whipping out a detention order. The detention today, extrajudicial detention, is accompanied by a denial. I'm just wondering aloud, why would we have documents that are so dissimilar that are most probably a forgery? We need an explanation from the two individuals, Inspector General and the Director of Investigations. And I would like to say that any alleged matter said by the caretaker who has not sworn an affidavit and who appears to have made a general statement, not a statement to the deponent. If you look at paragraph 14 of the respondent's affidavit, it says, the said caretaker informed officers that the second petitioner had left the house earlier in company of another man and 2 unknown ladies. He doesn't say he has been told by her, which he verily believes to be true. It's a marketplace statement. He said to the officers, this is hearsay, should be expunged, unless if the lady herself swears affidavit and avails herself for cross-examination. What if the 2 others he left with were an advance party to abduct, while the others come back and search? Those are things we can never know. I sit just down with one proposition. The coincidence of the house being broken into by the police, which they now admit, and my colleagues will be dealing with the illegalities of that, and his disappearance, and the conduct of the DCI and the police generally in this country in matters relating to abduction, leads to the inescapable conclusion that indeed they arrested him and then ransacked his house. I yield to my colleagues.
Very briefly.
Yes, Mr. Chairman.
No, I said from the point that I assume that the respondents recognize that we are in a country operating under the rule of law. And if they accept that fact, then a competent court having made an order, I've never seen orders that are so express and explicit like this one, directing the IG, Mr. Kanja, and the DCI, Mr. Amin, to produce Mr. Ndiangui Kinyagia on the 1st of July 2025 at 11 a.m. That's the first part of that order. It is 12:43 at the time I'm speaking. And the 2 gentlemen have not produced Mr. Ndiangui Kinyagia. This court specifically directed them that if they fail to produce him, in default, they have to attend court to show cause. So we all agree there is no production, but I can see they are not here. I'm only seeing Mr. Marwa. He's not the DCI, he's not the IG. So if we are operating under the rule of law, at the very bare minimum, the 2 gentlemen should be in court doing the explanations which counsel is purporting to do from the back. Because underlying all this is the liberty and the life of a citizen at stake. We may speak all the English, but there is an individual whose life and liberty is at stake at the end of the day. And that should be the primary concern of all the parties and the law. And in furtherance to that limb, my Lord, Mr. Ndiangui seemed to have only attracted the attention of the respondents.
That is the second petition.
The second petition seemed to have only attracted the attention of the respondents on the 18th of June.
On the 18th.
18th of June 2025, and that is, my Lord, as per the Annex 10, the replying affidavit, page 10. Sorry, on the 19th of June. 19th of June, as per the annexure found at page 10 of the replying affidavit, is a letter signed by one Zachary Kariuki, the DCI Operation Support Unit. And that letter, my Lord, it is the first time that the question of liberty of the second petitioner is being discussed. Before that day,
Referring to
page 10 of the replying affidavit of the respondents, it's a letter dated 20th of June. 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 Are the respondents, no other person. And it is also not in doubt that he disappears on that 21st of June. If it quacks like a duck, if it walks like a duck, it can only be a duck. And in their replying affidavit, they are speaking to recoveries of items in his house. Issued yesterday were complied with, we will be asking the two gentlemen and their subordinates whose names appear on the inventory to have been present at the residence of the second petition.
yes.
So, my Lord, as I conclude, I will pray that this honorable court, to the extent that we have this order still in force, to give dignity and and to assert the authority of the judicial process. With the participation and the presence of the two, Mr. Kanja and Mr. Amin, in person answering this question, and their subordinates who have signed this inventory. Only one agency in this country in the supporting affidavit of Florence Muturi have not been denied the presence of Subarus and the gentlemen in those Subarus in civilian in violation of the law as noted. They make no mention to them. Do give justice to the second petitioner and his family.
You want to add?
Yes, Your Lordship.
There
There are certain aspects, Your Lordship. I'll be
Which
speaking
ones?
directly to the affidavit.
Which ones?
Yes, Your Lordship.
Which ones?
Your Lordship, I'll be sticking to the contents of a supplementary affidavit, the issue of the arrest warrants, and amendments by manual for the respondents in terms of their interest with the second respondent.
But what has senior counsel done? What has Mr. Willis Otieno done?
Your Lordship, if you would indulge me, perhaps you would find that.
I will, but I want to find out
Yes, Your Lordship.
what you are adding.
Yes, Your Lordship. I'd be speaking to the fact of, Your Lordship, there was an amendment by counsel for the respondent that they are looking for the second petitioner and not investigating. I would wish to point out to this honorable
But that's what he
specific
said.
paragraphs.
But that's what he said.
Yes, Your Lordship. I'll be alluding to their replying affidavit where they indicate that he is a person of interest, as well
Yeah,
as
they have
our-
said that.
Your Lordship, the amendment was that they are looking for it. Your Lordship, there's a difference between a missing person, Your Lordship, and a person being investigated for having committed a crime. That was the distinction.
You know, we really have to try and focus on why we are here. You understand the council?
Yes, Your Lordship.
Yes.
Yes,
Today was meant to be a very brief day. So just let me know what you want to add. We have read this affidavit, haven't we?
Yes, Your Lordship.
We have read the inventories, haven't we?
Yes, Your Lordship.
Yes. So just add what you want to add instead of making a day very long. Give us your name,
I'm Mr. Abner Mango, Your Lordship.
Mr.
Abner Mango.
So I can have Mr. Mango.
Yes, Mango is fine.
It's easier.
The fruit.
So proceed, Mr. Mango.
Yes, Your Lordship, I'll be very direct and speak to what has not been. Your Lordship, just referring the court to the affidavit in support of the agency. Your Lordship, there is a miscellaneous.
Let's not go there. We read that affidavit. We are here. We are past that agency.
It has not been spoken to. It has not been spoken to, Your Lordship. There is the second annexure. The inventory was the first one, but the second annexure, Your Lordship, to the affidavit in support of the agency is a miscellaneous application, number E2362 of 2025. This is the affidavit dated 27th of June 2025.
So which affidavit are you looking at?
There's an affidavit in support of urgency. Your Lordship, just to give you a brief background.
I have to be there before you
Yes.
give me a brief background.
I'm taking you to 27.
So I'm looking for that document.
Very well.
Don't be in a hurry. You must be looking at a different document.
Yes, Your Lordship.
Which document are you looking at?
Your Lordship,
Give me
there's
the
a
title of that document.
Yes, there's a certificate of urgency filed on 27th of June, and there was a further affidavit in support of the certificate of urgency.
When here we go by the date, the document
Dated
is dated.
27th of June, 2025.
When is this urgency dated?
27th of June. 2025.
Certificate.
Yes, Your Lordship. And that is why I was giving you the background that the initial certificate was filed on 24, and having not been given any directions, another certificate of urgency was filed on the 27th of June.
And when was the application seen?
On the 27th of June 2025 is when Your Honorable Lordship gave direction. After the subsequent filing of the second certificate.
24th was which day?
24th was on Tuesday.
It was filed at what time?
24th at 9:34 a.m.
And we sit up to when?
You see? And Your Lordship, that's what prompted the
No.
Yes.
See, seem to be saying
Yes.
we were late in acting on your application.
Yes. Yes.
So we sit up to what time?
5 p.m.
Do you know when we saw this?
on 27th.
And you know it has to be allocated.
Yes.
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 So you know when it was allocated.
On 27th. That was after the subsequent certificate.
It can be dated 24th but filed on 26th.
No. We filed on 24th.
I can easily confirm here.
Yes, Your Lordship. We
Okay,
can
just
confirm.
check. When was
In
it
fact,
filed?
the first ground of that certificate was that we had filed on 24th. That was our first.
Who filed?
Through the firm of VRA.
It was not you. Sindio?
Yes, Your Lordship.
Yeah. So you are told we file. He gave an assistant to upload. Maybe the system was down. That week we had the system was down. Yeah. So you are banning.
Your Lordship, your attention.
Wait. No, but are you able to see at what time did they upload?
27 at 12:14, 30.
And he's saying they uploaded when? That is a certificate of urgency.
Yes,
The initial petition.
on 24th of June 2025 at 8:19 p.m.
You see? So who sits at night? Don't come here and make an allegation in front of the media. You accuse us as if we don't work. So that was
Your Lordship, my
24.
apologies.
Wait, this is just same umefanya mbaya, only that you didn't know. So that is 24th. Then you come here and see. That was day of the week. No, not 24th.
It's Tuesday.
It's on Tuesday. And then you sit from morning 8:30 up to some time before you
of the second respondent to the second petitioner is clearly alluded to. One, in the miscellaneous application, and two, to his ex account. That is the Ndidi, as well as the press briefing that has been relied upon at paragraph 16. You see.
That miscellaneous application number?
What is dated 26th of June.
And had the inventory,
Yes, Your Lordship.
which you have attached.
Which we have attached. Which Your Lordship now is materially different, as highlighted by Senior Counsel, in terms of the code, different from the one that has been presented in the replying affidavit. Your Lordship, more particularly, if you look as well as to the replying affidavit. But however, Your Lordship, if you look at
You know, I don't have it,
yes,
so just assist me. Where do you want me to see?
yes, Your Lordship, I'm getting it to you right now.
This is which one?
Your Lordship, I'm
which
at
paragraph?
paragraph 13, yeah? So 11 and 13, I'm at, and that, this is the second respondent's replying affidavit. So paragraph 10 alludes to a well-planned and coordinated plan to mobilize people, prompting the investigation to achieve. And now,
Which paragraph?
Paragraph 10, we are the second respondent's replying affidavit. in court today.
So the link is where?
Is at paragraph 16.
How do I go there?
Later, as you
You don't do that.
yes.
I'm supposed to see that in court, right?
Okay.
You want me to go and do it in...
In chamber.
So you should have linked us here so that we
Very
see
well.
what you wanted us to
We
see.
will have made
But
prior arrangement.
I'm not saying we do that.
Very well. So, Your Lordship, I will finalize with where Senior Counsel, our lead, Madam started from yesterday, Your Lordship. That it is only this Honorable Court, Your Lordship, by dint of Article 23(1), that is the guardrail of justice. And Your Lordship, under Article 25D of the Constitution of Kenya, which provides for rights that cannot be limited, non-derogable rights at D, includes the right to an order of habeas corpus. Your Lordship, we pray that you protect that right. Otherwise, Your Lordship, the citizenry will be left vulnerable and at the mercies of the high and mighty, and we urge this court to act with speed and uphold public confidence, the rule of law, and constitutionalism. Your Lordship, with the permission of Senior Counsel, requests that Babu Owino makes his maiden presentation before court. He has just one authority that he wishes to highlight.
Thank you, my lord.
Before you go, because I wouldn't want you to be interrupted.
Yes, Your Lordship.
So you want us to insist, use his words, DCI should come here.
Yes, Your Lordship. Based on
And
the IG. As per your orders issued on 30th day. Order number 5, compliance with order number 5.
Okay, because Mr. Babu
the first and second respondents have before Your Lordship obeyed the orders of this court.
the order was, Mr. Maro, and I don't want to go there. I'm just making an inquiry.
Yes, Your Lordship.
Because I should have started with where are your clients? Because that order was not ambiguous. It was probably you seek some
Your Lordship, the
clarification.
order is quite express. And
So just answer that question, where are your clients?
Your Lordship, my clients will attend this court.
No, they were to be here at 11. So they told you they're coming at what time?
Your Lordship, I have no information on which time is supposed to be here, Your Lordship. Your Lordship, and that is why when I was closing my submissions, I requested for more time, Your Lordship, so that you can conclude.
You didn't ask for more time for them to come. You didn't explain anything about the order You already said you don't have the subject.
Your Lordship, I actually did. I commenced my submissions. Yes, Your Lordship. And when I was actually going to respond to all the issues that my colleagues have raised, I was actually going now to close on that particular issue. I believe I still have an opportunity to address this court so that they can feed into the gaps that have been raised.
We have come here first. Very simple. Very simple exercise. Very simple exercise. Mr. Mara and the rest of you. So, Babu, let me give you time. You say as much as you want to say.
Thank you very much, my Lord. My Lord, I would like to start by the seriousness of this matter, that the second respondent, the fifth and the sixth, to show the unseriousness that they have, my Lord, they have not even taken stand before you as we speak. My Lord, to speak to the writ of habeas corpus in a case of Etrelita de Martinez versus Director General and others, that is in Philippines, and the case which was cited with approval in the case of Masood Salim Hamed and another versus the Director of Public Prosecutions, they defined habeas corpus as habeas corpus generally applies to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. In another case, this court said that the ultimate purpose of the writ of habeas corpus is to relieve a person from unlawful restraint. It is devised as a speedy relief from unlawful restraint, my Lord. And therefore, my Lord, this writ of habeas corpus is unlimited under Article 25, whatever the circumstance or whatever the situation. My Lord, as I conclude, the architects of our Constitution sought to address a historical concern. And the survivors of the Nyayo regime, my Lord, endured a very brutal police force that held them incommunicado without trial. And even during that time, my Lord, in the case of Kanja, who was detained without trial and later on murdered, was exhumed and the body was recovered for the families to see. So it means, my Lord, that even during the Nyayo era was better than the era that we have, because at the moment we cannot even get a body that we want. So it is my prayer, my Lord, that this court stamps its authority and help this nation secure justice. Thank you so much, my Lord.
The last word is? stamp its authority and
the court to stamp its authority and help Kenyans get justice, because, my lord, despite the 5th and the 6th respondents not being present in court now, we are patient to even wait for them in the afternoon, because yesterday, according to the presser that the DCI director issued, he said that he would be in court today. Thank you.
thank you. Mr. Mara, do you have a right of reply?
Yes, Your Lordship, I have a few.
What do you want to say?
Your Lordship, I want to begin first with the authority that my good friend Baboino has just.
We are not discussing the authority here.
Yes, Your Lordship, but this is very critical, Your Lordship, so that we get to appreciate.
Everything is critical. To me, Mr. Mara, there is nothing more critical than when it comes to human life.
I agree, Your Lordship.
So let's not debate. Let's just be here.
Yes, Your Lordship.
When we are going to discuss about habeas corpus, we better understand Article 125C.
Yes, Your Lordship. I appreciate that.
It cannot be more clearer than that. So let's not go there.
Yes, Your Lordship.
Just address me what you wanted to say.
Yes, Your Lordship. In the same authority that Baboino just read, Your Lordship, the judge, in that very authority, the first authority, the judge said that it has been established the general burden in a habeas corpus application must be pursuant to Section 107 of the Evidence Act and remains with the petitioner.
We have not gone there.
Yes, Your Lordship. The court said this is necessary for this court to appreciate.
Which court?
The High Court, Your Lordship, that the petitioner must establish any competent and convincing evidence that the missing person on whose behalf the petition or the application was filed is under the custody of the respondent. That is what is missing, Your Lordship, here. It has not been established that indeed the second petitioner is in the custody of the respondent. Your Lordship, my colleague Mr. Mangwa said that the delivery of this affidavit was not at the scene of the crime. Your Lordship, my colleague has been very selective in reading the affidavit that I filed. If you read paragraph 1, I believe Mr. Mango understands this, that I am a police officer in the meaning of chapter 84, the laws of Kenya, one of the investigating officer in this matter. He has confirmed that indeed he is the investigating officer in this matter. A lot has been said regarding annexure number 1, that is the inventory, Your Lordship. The only person, Your Lordship, with the competency to address the authenticity of that particular annexure are my clients, because they are the author of that particular annexure. At paragraph, Your Lordship, paragraph,
The only person?
my clients, Your Lordship, they are the ones who came up with that inventory. So they are the only person who can
Mr.
speak
Mara,
to
your
them.
respondents,
Yes.
your clients include the Cabinet Secretary, the Attorney General.
Yes,
So who do you have in mind?
the second respondent. At paragraph 16, Your Lordship, the affidavit that my colleagues have been reading was contested in part.
Yes?
It reads that we've noticed that the copy of the inventory annexed to the affidavit of Florence Uturi has omitted the caretaker as having been a witness to the inventory. So we have not looked at that particular affidavit. The only annexed, Your Lordship, that you believe is the original, and that was taken at the scene, the one that we attached. This is annexed number 1. There is no application that has been made before this court calling the author of that.
So that inventory attached to the petitioner's affidavit is contested.
Yes, is contested. And my colleagues, Your Lordship, are not experts in ascertaining.
Neither are you.
Yes, Your Lordship. That is true. So we can.
These are your colleagues.
Yes.
You are their colleagues. So none of you is competent.
That is true, Your Lordship.
That's better. Well
Yes.
put.
So we cannot say that this is fake and this is original. Yes.
Anything else?
My senior, Mr. Willis, has again told this court that the investigations are not ongoing, and we stopped investigating the petition. Your Lordship, if you look at paragraph 20, the second petition still under investigation. That is paragraph 20. And
Of your affidavit.
Yes, Your Lordship. Your Lordship, that is all for the respondents. Thank you.
I'm seeking the court's permission to say just one sentence.
Just a minute. Yes.
My Lord, with your permission, just to say, once the respondents admit that there is contestation of the two documents, they are indeed buttressing our case that we need the DCI and the IG here, and that the court will not be able to completely adjudicate on this matter without that. We are pleading, this being a matter touching on the life, that if it pleases the court, this afternoon would not, it's already afternoon, but late afternoon would not be too soon. Would be happy to just hang around and wait and deal with this matter to relieve the family of the anxiety. Most obliged.
Senior counsel,
Yes, my lord.
in matters like this, I don't know how you want us to proceed. Mr. Maro,
Yes, Your Lordship.
you contest their inventory, the copy they have attached.
Yes.
They contest yours. Did you hear them?
Yes, I heard them, Your Lordship.
So the documents attached are contested.
Yes, Your Lordship. But the important is that they did
No,
not make that.
let's not go there.
Yes,
Those documents appear to originate from your end, your clients,
correct, Your Lordship.
both of them.
The only one that I believe originates from the client is the one
Don't
that
be
I
so
attached.
defensive. It's not you.
Yes.
Don't speak as if it is you who made them. Someone made the document. We are trying to establish the truth.
That is true, Your Lordship.
They are not saying you did. They are saying someone did it. And we clearly can see. We don't require to be a professor to see that
Correct. Your
there is
Lordship.
something there.
Yes.
Who made the inventory?
It is a gentleman by the name Leonard Sigel.
CLA.
CLA, yes, Your Lordship.
Robert, do you have that? Do I have that?
Both actually have the name.
You have their copy?
A copy of the letter.
Yes, the one you contest.
I don't have, Your Lordship, and that is why I still insist.
It's in the petition. And the source is clearly where it was filed in the lower court.
Do you have it?
Not on the documents that I have, Your Lordship.
Were you submitting the petition?
I only got the motion, Your Lordship.
You are able to get onto the CTS?
I tried, Your Lordship, this morning, and these are some of the documents that I have retrieved. Considering the timelines you gave me to comply, Your Lordship, I confirm even our office has not been served with that particular application. So I have to retrieve the same from the CTS.
Your Lordship.
No, please, if you are speaking, speak through me.
Yes, Your Lordship. When we appeared before you yesterday, Your Lordship, we did allude to an affidavit of service, which was not contested. We clearly.
I'm not going to go back to service. No, don't take me there. Do you have a copy of the petition, Mr. Mara?
Your Lordship, I have a copy of the motion, not the petition.
I'm asking a specific question. Either you have, you don't have,
I don't have.
you don't have.
Yes.
Mr. Mango, do you have a copy of the petition?
Yes, Your Lordship.
Give him. Does he have the attachment? No, no. Does it have? The one you are giving him?
Yes.
Just give him.
I have it, Your Lordship.
So you have the attachment.
Yes.
And it is theirs. They filed it in the lower court.
So the copy you have,
Yes, Your Lordship.
seems to say, to suggest it originates from your client. Seems to.
Yes, on
I'm
the
not
face of
saying-
it, Your Lordship.
That's what I mean. Seems to.
Yes.
Contain the same information.
Yes, but this has 7 items. The one
Correct.
has 6 items.
Yeah.
Yes.
So they contest the one you gave
Yes.
because of one or two some, and you contest the one they have. Yes. Are they assigned by the same officers?
Your Lordship, yes, they're signed by the same.
They appear to.
They appear
Let's use the word they appear to have been signed.
Your Lordship, of course, discovered that in which even the one I have has 7 items, has 2 pages.
There is overwriting.
Yes. Not all. Has 7 items.
There is some overwriting.
On this,
I'm just confirming before we leave here so that it doesn't, it's not said that some document was sneaked.
that is true, Your Lordship.
I'm referring to the document you have just been given by the petitioners.
Yes, I confirm.
Those documents are signed. They clearly show where. Then the one you have given them,
We have. Your
you also have.
Yes.
That one you have.
Yes.
Okay.
Yes.
Would the court allow us to clarify something about
No, no, no. You people said what you said. I'm
I
trying.
just-
I'm trying to figure out, Senior
Yeah.
Counsel.
yeah. It's just that both documents originate from them.
No,
That's
no.
what I wanted
He said
to point out.
they appear. I used the word appear because I didn't want to say they came from him.
They filed it in another court.
That has been said.
Yeah.
It's on record.
Okay, thank you.
Where is the deponent of your affidavit?
Because you can't really keep it.
Where is the officer who saw the affidavit?
Last I checked, the lordship, he was in court. Maybe I can give him time to check for him.
When did you check with him last?
Before I got in court, I had a discussion with the officers.
He was here.
Yes.
Is he still here?
I'm not sure, the lordship.
Sergeant Samuel Itegi. Samuel Itegi, you are here?
Yes, sir.
So, your colleague says someone promised that he would be here. Did you hear that? I didn't watch. I don't watch news, so I didn't watch anything that was said.
In the lordship, I also do not watch news. By the time the DCI was making the purported statement,
But that was after we issued an order that they should be here.
yes, your lordship.
So he was responding to the court order.
I am not sure if he had been served with the order, your lordship.
Mr. Mara,
That's why I said he'd come.
Mara, if we go that way, we are going not in a, you know, these things, you are in court and you directed that they be here. So I don't know, but I'm not saying they shouldn't be served. How do you want us to proceed in view of the issue that is before us?
Your lordship.
And in view of the fact that my order was very clear.
Your lordship, I wish first your lordship to say that this is a very difficult matter. I understand somebody is missing, and it is in the interest of both myself and my client, and even the petitioners, that the second petitioner is found.
Yes.
I hope.
And I wanted the second petition,
Yes, your lordship.
live or dead.
Yes, your lordship.
That's all I want.
Yes, but it is my
They wanted
prayer,
the body, I said I want him.
but it is my prayer, your lordship, that he be found.
So we want him.
Yes. So, your lordship,
When can we have him? Because someone is keeping him.
Lordship, that is a very difficult question posed to me. I cannot confirm on the date and time. I will only be asking for a bit of time so that I can engage my client, your lordship. I cannot speak on their behalf that with certainty within this period, the second petition will be confirmed, your lordship. You can give us a bit of time.
How much time? I wanted that person, whether he's dead or
Your
alive.
lordship, as indicated from our affidavit, clearly you've seen the investigations are ongoing.
They have said their story.
Yes,
You have said your story.
yes,
I'm looking at the two stories.
yes.
Yes.
Your lordship, in terms of timing, your lordship, you leave the discretion of the court. You cannot with certainty say that 3 or 7 days.
We are not interested in any other thing
Yes,
other than the human being.
I am also interested, your lordship. Yes,
So
yes.
when can we get to this human being?
And your lordship, that answer, it will be very difficult for me to give.
You know, Mr. Mara, tell your clients,
Yes.
and these people, I'm also speaking to these people.
Yes,
There is no way a Kenyan will get out of his abode and vanish from this world without trace. It's not humanly possible.
that's correct, your lordship.
So let's stop doing drama and stick to what the Constitution speaks to.
Yes,
We may not like it. We gave it to ourselves. Those are the words. And the future generation. So when can we have this person? He may be hiding, I don't know.
there's also
Yes,
that possibility.
because your clients are pursuing him,
Yes, your lordship.
and he has to live like an animal. So, when can I have this person in court?
Your lordship, may be given 7 days
Eh,
And Your Lordship, he can't be found even before the lapse of 7 days.
He has been missing since
I believe
21st. So today is 10 days. Yeah.
Your Lordship,
All we want
yes.
is this Kenyan.
Your Lordship, the amount
Where
of
is
money-
he? Nothing more. We are not interested in trouble. We're not interested in anything. There is a human being missing. So where is he? Is he alive or dead? Just that. The response now is on me. They are asked, looking upon this court, to get this person alive or dead. And we all have a responsibility.
And Your Lordship have confirmed, and I wish to direct that-
You know, I've read the pleadings, Mr.
Yes.
Mao. Let's not go there. I've read the pleadings. Yes. We take your story with the forcefulness it deserves. We take their story. We balance the two.
Correct, Your Lordship.
I didn't watch the video these people wanted me to watch, so I don't know what was said in that press conference. But let me make my few remarks here. Not the calendar. Calendar.
Return.